In India's constitutional system, the balance of power between the union and the states often depends on few carefully drafted provisions. Recently, a major constitutional development reshaped this balance once again. The Supreme Court delivered its opinion on 16 presidential reference, clarifying how governors and the president should deal with bills passed by state legislatures. This opinion has been widely discussed because, on one hand, it tries to uphold separation of powers, but on the other, it raises serious questions about the future of federalism. Today, let's break down what the court actually said and why it matters and how it compares to past interpretations. The debate began when several states complained that the governors were taking an unusually long time to act on bills. Some bills remained pending for months, even years. In April 2025, the Supreme Court delivered a strong judgment trying to address this issue. It set a 3 month deadline for governors to act on bills and even used Article 142 to grant deemed assent to some bills passed by the Tamil Nadu Assembly. But the Union government then sought clarity through a presidential reference. The question was simple: can courts impose timelines on governors or the president? And can inaction be treated as consent? The recent opinion overturns key parts of the April decision. The court said that no fixed judicial timelines, no deemed assent, and governors have discretion in assent matters. And what exactly can a governor do? We will discuss this here. Article 200 and 201 of the Constitution deal with the governors and president's assent to bill. These articles say the governor must act as soon as possible. The court called this phrase elastic and held that it cannot be converted into rigid deadlines by the judiciary. In simpler words, the Constitution does not mention a fixed number of days, therefore, courts cannot invent one. Second is no deemed assent. The court held that Article 142 cannot be used to bypass the constitutional process. A bill becomes law only through actual assent, not because time has passed. This directly contradicts the earlier ruling that treated delays as automatic approval. And third one is governors have discretion in assent matters. This interpretation is crucial. Normally, a governor must follow the aid and advice of the Council of Ministers, but the court said that when dealing with bills under Article 200, the governor has independent discretion. This decision is controversial because during the Constitution's framing, the phrase "in his discretion", which existed in the Government of India Act 1935, was deliberately removed from Article 200 and 201. The framers intended the governor to be constitutional figurehead, not an independent authority over state legislation. Yet the court concluded that some discretion still exists. And next is, what exactly can a governor do? The court clearly listed the governor's options, and these are also mentioned in the Constitution. It can give assent, withhold assent, and return the bill once for reconsideration. And third one is reserve the bill for the president. And however, there is a twist. If the assembly passes the bill a second time, the governor cannot withhold assent, but can still reserve it for the president. This means the state legislature's authority, even after reaffirming a bill, is not final. Then what about the president? If a bill is reserved under Article 201, the president can choose to assent or withhold assent. The court held that the presidency also has no fixed timeline. The president is not required to consult the court again. The court cannot review the merits of the president's decision. This means a bill can potentially remain pending indefinitely. While the court removed timelines and deemed assent, it did acknowledge one safeguard. Courts can issue a limited mandamus if there is prolonged, unexplained, and indefinite delay. This means courts can order the governor to make a decision, but cannot tell the governor what that decision must be. However, the court did not define what court as prolonged. Is it months, a year, or more? This burden is now on states to prove unreasonable delay in every case. Two major constitutional commissions had taken a more state-friendly approach. One is Sarkaria Commission and another is Punchhi Commission. In Sarkaria Commission, the recommendation was Governor Act within 6 months, and it states that reservation for the president should be rare. And Punchhi Commission also suggested that governors should not interfere with the elected state government's will. Both commissions argued for stronger procedural safeguards, but the court's opinion did not adopt these recommendations. Why critics call it a blow to federalism? There are growing concerns that this opinion effectively increases the possibility of executive overreach. Here's why. No timeline is equal to more room for delay. State bills can now be kept pending indefinitely unless courts intervene, and intervention itself is limited. Next is reservation power becomes a backdoor veto. Even if a bill is repassed by the assembly, the governor can still reserve it for the president, and the president also has no deadline. Next is no remedy for delays at the union level. Once a bill reaches the president, the state has no constitutional tool to push for a decision. And another is state lists of subjects are not protected. Even bills dealing with state exclusion matters can be blocked or delayed without accountability. Many states, especially these governed by parties different from the union government, have already experienced long delays in assent. This opinion gives such delays a constitutional cover. And what should be the final reflection? The Supreme Court's recent opinion tries to maintain separation of powers by preventing the judiciary from stepping into the domain of executive. It reinforces that governors and the president must follow constitutional procedures, not judicially created ones. However, by removing timelines, refusing deemed assent, and expanding discretion, the opinion also weakens the safeguards that protect the will of elected state legislature. In short, the decision stays loyal to the literal text of the Constitution, but has opened the door to outcomes that may run against its federal spirit. And one thing here we should notice that this is not a verdict, this is not a decision, this is a suggestion that was given in context to 16th presidential reference.